Hearing the appeal Warner against Scapa Flow Charters.
Yes. I should say at the outset, Mr. Howie, that we think this is quite a short point, so we think that a day's time estimate is somewhat generous.
I'm pleased to hear it, my lady. I have a bad reputation for underestimating cases, so I'm to be accused of overestimating. I shall probably have to ask for that to be recorded for posterity. My Lords, in this appeal, I appear with my learned junior, Ms. Charters, on behalf of the defendant and appellant. My learned friends, Mr. Milligan and Mr. Pugh, appear on behalf of the pursuer and respondent. As the court will have seen from the notice of appeal, the statement of facts and issues, and the cases which have been lodged on behalf of the respective parties, the underlying facts of the case are of rather limited importance to most of it, as my Lords will be aware, because this comes on appeal ultimately from a procedural discussion in the Court of Session. It is simply assumed that the case made by the pursuer on her record is correct for present purposes, and reference is made to those. I don't believe I need to trouble their lordships with any more about the facts than that, frankly, because all that simply matters is about dates, and even that is a matter of agreement. It is entirely accepted that this is outside the 2 years and inside the 3. If I proceed by reference to the case which has been made on behalf of the appellant, it may be said, I suspect, that the first 3 or 4 paragraphs are effectively uncontroversial material. These paragraphs set out basic material with which I'm sure their lordships are familiar, and I apologise if it's a series of statements which they regard as being of the obvious, down to about the 4th paragraph. In the 5th of the paragraphs, I proceed to set out what I contend is the approach which falls to be followed, at least in this country, in relation to cases under Article 16, which I characterise as being a 2-stage approach. It may have been seen that the reason I put in the qualification about the United Kingdom is that in the Canadian papers, cases which appear in the papers, this approach wasn't particularly necessary, as Canadian federal law meant that whatever it was intended by a suspension or an interruption. Canadian law didn't have it, and therefore the case was, as it were, cut down at the start. But for this court, I can't say that it's as easy for me as that. And therefore, I suggest that the approach is stage 1 to determine what, in the correct interpretation of subparagraph 16.3, for that's the critical one, in the case of a court which the Act doesn't apply the article, is meant by the phrase the grounds of suspension and interruption of limitation periods. And once one has an answer to that question, one asks oneself whether the legislation put forward by the pursuer to save his action is one which properly answers the description, whatever is correctly understood as being suspension and interruption of limitation periods. That approach is uncontentious, as their lordships will have noticed from the case for the respondent. So I move then to the 6th schedule of the Merchant Shipping Act, which is in the tabs. I suspect the court is well familiar with it. Tab 1 contains the Merchant Shipping Act with the section in it about the Athens Convention in Schedule 6. And the passages concerned will be found, first of all, with respect to section 183, page MS number 126, and in respect of Article 16, MS pages 137 and 138. The basic structure is one which I submit is not uncommon in the sphere of international transport conventions, in that the action for damages is required to be raised within a period of time. It's a limitation period in this case of 2 years. It has to be calculated in a given way, and 16.2 is a paragraph on which I place some importance. It provides that the limitation period shall be calculated as follows. I miss out A. B, in the case of death occurring during carriage, from the date when the passenger should have disembarked. I needn't trouble with the rest of that paragraph. That's agreed to have been a date in August 2012 in this case. And then subparagraph 3, which is the main issue in the present case. The law of the court seized of the case shall govern the grounds of suspension and interruption of limitation periods, but in no case shall an action under this convention be brought after the expiration of a period of 3 years from the date of disembarkation of the passenger or the date when disembarkation should have taken place, whichever is the later. More or less for completeness that may have some minor significance, the fourth part of Article 16 provides that the limitation period may be extended by a declaration. There is no suggestion of any such declaration in this case. All cases of the present class involving death from seagoing ships, and as is agreed applies to this case, must be brought under the Athens Convention because of Article 14 on MS 137, which requires that no action for damages for the death of a passenger shall be brought against a carrier otherwise than in accordance with this convention. And I place a bit of importance, as their lordships will have seen, on otherwise than in accordance with this convention, for I say that indicates that one cannot have provisions which would have effect of contradicting what appears in the terms of the convention as written into the law under the Merchant Shipping Act. And my submission is that that's almost a necessary consequence of the purpose of this kind of legislation, which is to secure a degree of international uniformity, and that therefore a meaning for the words suspension and interruptions of the limitation period and 16.3 should be common, if that's at all possible. It's the ideal situation, so that the area in which the Lex Fori is to operate is, as I say, a matter of common acceptance and not to be left to more or less expansive ideas of different legal systems.
But how can that be so when the convention expressly refers to the law of the court seized, and that the law will differ from one place to the other?
Oh, indeed. I'm not suggesting that the ultimate answer as to whether or not X is a ground of suspension in a given legal system is going to be the same.
No, but uniformity is unattainable in this field, isn't it? Is it?
No, my lord, I would respectfully submit that uniformity is attainable in determining what is it that is the animal that is called suspensions and interruptions. Next question, and this is why I pose the two-stage question, is once one has an answer to that, which is the bit which should be, as I submit, the matter of common acceptance, if it be possible. Next question is, does the specific piece of legislation in the law of the forum meet that description or not? And that may be so in some cases and not in others. And certainly different countries' grounds of purported suspension or interruption will not be the same. They patently aren't. I quite accept that.
You're saying the question is what sort of animal
Yes.
is suspension or interruption? And then different countries will have different periods, different grounds possibly, but you're saying it should be a common interpretation of the kind of thing it is.
Yes, I say, what is the animal? And the next question is that one of those animals?
Yes.
And I suggest that there can be a common answer to what is the animal. And in relation to that, I should call attention to one of the a little passage in one of the Canadian cases, MS 366.
So, in a word, what's your definition of the animal?
I say the animal is that it is a mechanism which determines what is to happen to the running of limitation after the halting event has itself ceased. Does it A?
After it has ceased?
Yes. Does the limitation period resume from the point at which it had previously reached? Does it start afresh? Are we looking at something which is a break in the running of prescription or limitation, as the case may be, which had already started, or are we looking at something else, such as a scheme for counting up the numbers for the period of prescription or limitation in the context of that particular law.
If you had a provision in the law of the court seized to the effect that time is not to run during the minority of the claimant, that wouldn't count, is that right?
I say that would not count because if prescription does not run, there is no question of it being suspended or interrupted. It's just not running.
You say it has to have started before it can be
started.
suspended or interrupted. That's your basic point,
That's
isn't
my
it?
central point, milady. It has to have started, else it is not suspended, it is not interrupted. If one is looking at a postponement or a deferment, I say that's not consistent with the statutory scheme, because the statutory scheme in 16.2 has said to me that one must calculate my 2 years from a given start date. So on the assumption that the statutory scheme is intended to be internally consistent, and I submit that must be the underlying assumption, the meaning of the phrase suspension and interruption must be such that it doesn't postulate a contradiction of the starting date, being the date when Mr. Warner would have got off the vessel.
Do you submit that there is any underlying statutory purpose which explains the distinction between a deferral and suspension as you interpret it?
I submit that the reason for it is because I don't submit that there is a policy reason which can be determined from the Travo which says we have decided this because A, B and C. So far as I have been able to ascertain, there is nothing in the Travo which indicate that there was any such policy that was discussed at least and recorded in relation to why this was put in place. But I say that it is perhaps one of what Lord Steyn once called the innumerable compromises of international conventions. It is using a familiar conception of suspension and interruption which appears in many a convention to say, here is where we're going to draw the line, here is how we're going to, this is what we're going to remit to the lex fori, and other things we're not. It is, I say, not so much a policy about individual ideas about whether we should protect minors or the vulnerable or whoever else. It's a matter of saying, what are we remitting? How far a degree of certainty are we prepared to sacrifice to national laws in relation to the grounds that they will have? I say it's simply a matter of a consequence of a determination that here is where we are going to draw the line for whatever reasons it may have been that the several delegates had.
It does have a consequence that that minority, which would be a ground for a limitation period or prescriptive period not running under many legal systems, falls out of account. That's your whole point.
Yes.
It isn't easy to see a rationale for that view being adopted.
Well, my lord, this was a point with which I was taxed in the court below, and I say that this is not actually of great significance, because what the danger of this is doing is causing one to look at construing the International Convention by reference to what is done in A country or B country, and may not be done in C country. Now, in the case of minority, I would accept that many countries will have something or other about minorities, but equally it will be expected, I venture to suggest, and perhaps one can infer this was what was underlying this, is the expectation that in relation to a minor, there is somebody who is not a minor, who has the right under the local law to sue on their behalf for the damages within whatever the period of time may be on their behalf, and that therefore it is not necessary to deal with a suspension of time or an interruption of time for such people. Time doesn't run if they have no such person available to them, so they need stand in no protection by way of suspension, deferment. And on the other side of the coin, those who insure people like ship owners are entitled to know there comes a point at which they can close their book. And that they would do, presumably by reference to looking at the law on limitation in the court to which they are subject where the accident may be thought to happen, and close their book on that footing. One of the ironies, if the inner house is right, is that as between England and Scotland, there is at the moment a very nasty surprise lurking for such insurers, who may find that, having read Hyam if we postulate an accident on one of the P&O ferries over the Channel. They've read Hyam. The solicitors who had conduct of the child's case have unfortunately, through their negligence, allowed it to fall foul of Hyam. They've overrun the 2 years. There is no extension under Section 33 available. And it would be no great surprise if the underwriters then said, well, we needn't trouble about that anymore and close their book. It would come as a nasty surprise to find that because the solicitors for the professional indemnity insurers of the originally negligent insurers were one of those now increasingly common firms which have cross-border offices, that some clever young Scotsman has been handed charge of the case concerned, and he says, wait a minute, P&O Ferries happens to have a place of business in Stranraer because they run the Northern Ireland Scotland Ferry. So the thing to do, because this now attaches limitation to the Lex Fori, is, and we've still got time before the in no case elapses, let us take this case north, sue in front of the Sheriff of Dumfries, and the whole matter of limitation has evaporated. Our insurers are off, and suddenly it's the problem of the shipowner again, who has closed his book. And that, I submit, is unlikely to have been the intended consequence of this, because I suppose in a partial answer to my Lord Sumption's earlier question, in these conventions, one of the issues is about working out what the level of protection certainty which is going to be afforded to carriers is, hence all the material that is much contested about what limitations of liability are going to be, what the figures are going to be. And the other part of that same equation is, what is it that he has to know to have certainty about when he may close his book on the risk to him of the case? And I say one of the difficulties with what we've got here is that he can't necessarily do that. What he needs to know is to know what is the kind of animal he's got to deal with, and then look to what the particular cases may be that in those countries to which he may be subject under Article 17.4, he could find himself in difficulty. I apologise if that's an overlong answer to my Lord's question. The point which I had been going to call under their Lordship's attention, and I'll simply note it for them, given that my lady in the chair's indication that they consider this a matter of some shortness, is the M366 point in paragraph 12 of the Shibena Caddy case. I'm referring here to the last sentence or so about the important objective of uniformity in Canadian maritime law and the international community of maritime states is not to be undermined by the application of individual and different provincial statutory regimes.
Well, where is that to be found?
MS 366 in the case by the name of...
366?
Yeah. Sorry, I thought I said the number. I apologise if I omitted it. Now, although that judge is there discussing, of course, provincial and federal rules in Canada, the same line of logic, I submit, applies just at the next stage up, as between, say, Scottish rules and, or any individual country's rules, and the international community. Now, the next paragraph that I deal with in the note of argument is unsurprisingly also uncontentious and is the well-known rules about the interpretation of international conventions. And if their lordships will forgive me, I don't intend to detain them by long quotation from this. I mention the critical passages, or what I submit are the critical passages in the Scottish cases, which are to be found in tab 5, the King and Bristow case, and there are also well-known passages from Stagline and Fothergill. These are the passages which indicate that one looks first of all to the ordinary English meaning of the words and then goes on to look at other material such as foreign case authority, travaux, etc. And that is what is done in the following paragraphs, quite honestly following the order of argument dictated by the speech of Lord Hope of Craighead in King, in paragraph 75 and following. And what we are seeking, as I submit, is to find the basis for the material of international common acceptance rather than anything governed by domestic precedent, which is why I accept, for example, that the highly unusual term use, which we sometimes put the word suspension to in Scotland, clearly has nothing to do with it. The other point, which may be of some materiality, is that, of course, the line of interpretation doesn't exclude the possibility of looking at foreign texts and foreign languages, as I quite accept from a question which was put at an earlier stage. And it also accepts that there may be issues about terms of art as well as ordinary meaning terms. So I say at the 8th paragraph that the appropriate place to start looking is the ordinary and natural meaning in English of the words suspensions and interruptions. And I also note that one should read this, as Lord Hope tells us, in the context of the Convention as a whole, what one would expect to do with any formal piece of writing. And of course, the reason one is doing that is to try to protect, amongst other things, against internal inconsistency and contradiction. One may not succeed, but it is reasonably to be taken as an expectation that the purpose of the draftsman is not to bring that about. Now, I indicate in this that it is to be accepted, and my lords will have seen in the papers and the authorities various citations from dictionaries, and that the words suspensions and interruptions, as I suggest, are words which are nigh on similar, indeed, heading for what I think Sir Ernest Gowers once called Siamese twins, words which on the other side of the word and mean almost the same thing, as and when, unless and until, neglect and default, etc. And that the common denominator they have is of breaking into the tract of the running of things on foot. I accept, of course, that the word suspension is capable of meaning things beyond that. Interruption, one wouldn't really expect to go beyond that. And I point out in the note of argument that even though they appear with the word and between them, and that's my Siamese twin point in the footnote at the bottom, that doesn't necessarily mean that they're denoting different things. They may simply be of the unless and until category. Lawyers are rather given to that form of prose. Now, I submit that the ordinary usage of the word interruption, which I accept is not the one my learned friend founds on, is certainly of the variety of breaking into something that's already happening, the intermission. I suggest, however, that the more natural meaning, at least, of the word suspension is similar. And I offer the example to demonstrate that it presupposes something, generally speaking, already on foot, the suspension from office or the train that sadly didn't leave from the platform yesterday morning. I should have known better than tempt Providence with that example. The natural meaning, I submit, therefore, is the one in Hyam for the reasons I pointed out, and they probably don't bear much elaboration beyond what I've said in the statement of the argument.
You're probably right that that's the way it's more commonly used, but
yes.
Obviously there are examples of suspended being used in a sense where what's suspended isn't already on foot.
A suspended sentence might be an obvious example.
Yeah. Yes.
In a legal context.
In a legal context, and my answer to the suspended sentence, which is an example played against me by Mill and Friends when they put the respondent, is that that's actually a technical usage. Some of the other versions of suspension I would concede could be regarded as more ordinary English. I use deliberately mundane examples because I submit that the ordinary common usage of English turns up in the mundane, and that there are undoubtedly circumstances in which you could say that things have been suspended, which would be synonyms for postponement or deferral. I'm not going to stand here and argue something silly that they're not. But what one does equally see is in these dictionary definitions, we find, for example, at MS 320 and 299, we'll find the definitions for each of them using the common phrase intermission, which
Don't
is...
you have to ask, what is it that is being suspended? I mean, what's being suspended, according to Article 16.3, is the limitation period. One can quite see that if you interrupt an limitation period, that means it started and it temporarily stops. But if you suspend a limitation period, it's the period itself that you're suspending, isn't it?
With respect, my lord, no, I submit that what one is doing is in this connection because of what I'm to come to about the context, I say that's not so. If one divorced oneself from a context, of course it would be possible to say that one of the potential meanings of suspension is deferment, and that could be as true of a limitation period as it could be of anything else. Again, it would be silly to dispute that as a proposition. And therefore, I accept that as a matter of possibilities of English, even if I say the more natural and ordinary common usage, if you will, which I submit is what one is starting with in an international convention, is that it is the natural way to use the words is to say, it's not a deferment. There are other words one would use, postponement and deferment or extension or whatever, and we see indeed in some of the places at least those words being used in addition. And therefore, I submit that's, if you like, my starting point, but I concede that I don't contend that I can win the war there. I can't. That is possible to say, and my learned friends do say, that the correct meaning to give to this word is a different one, covering deferrals and postponements. But I say that's not so, because what we are dealing with is a situation in which this is to arise in the context of not any old limitation period, but the limitation period in the Athens Convention, which is operating from given dates which are predetermined and in respect of which mandatory terms on their running about the start date are set out. The word shall is used. Must has become popular in some more modern legislation, but otherwise one would say there is scarcely a more mandatory phrase could have been employed. And having said that phrase and used that word, I say that the statute doesn't brook any substitution of the date from which to start from the one selected by the lex fori. And I cross-refer back here to Article 14, and this is why I referred the court to Article 14 a little earlier, which says one may not have an action conducted other than in accordance with this convention. And one of the bits of this convention in accordance with which one must operate is that the start date is the predetermined one in 16.2, and if suspension is not to contradict that, and leave one in a state of confusion about which of the two one is dealing in, and the meaning which is appropriate to employ, whatever the possibilities in the dictionary may be, in relation to suspension and interruption in this particular case, is one where it does not mean deferment or postponement, because that which is deferred or postponed does not begin on the disembarkation date. It begins on the day when whatever it is that is the source of the deferment comes to an end. And that, I say, is a different date, and it's not permissible to go around substituting a different start date. A proposition indeed accepted in the court below, because it is the reason for which the widow's claim was disposed of. And I say that the same argument goes here. And the Inner House's view was that a suspension meant the deferment of something otherwise about to happen, i.e. they went for the deferment or postponement interpretation. And my response to that I set out in writing again, as their lordships have noticed, it's very short and it doesn't admit of a lot of elaboration. I say not so, that the start date of a limitation period, if deferred from date 1 to date 2, is not calculated from 1, but from date 2. And that in Athens terms, that would mean ignoring what it says in 16.2 and substituting some different period, whether it's the date on which majority is achieved, if that's achieved at all within the period of the period before the portcullis falls and the in no case clause, 3 years at the time of this accident, now increased to 5, and that that is, in essence, to counter what is said in 16.2. And that since we're supposed to be reading this as a whole on the view that it is unlikely that there is intended to be any such contradiction.
There's an inconsistency between the suspension or interruption and the operation of Article 16 on either possible meaning of suspension. On your submission that it means effectively the same as an interruption, it's inconsistent with 16.1, because that provides to be time barred after a period of 2 years. So on any view, sub-article 3 is saying that notwithstanding 1 and 2, different results are to follow in certain cases.
With respect, my lord, I would submit not. Article 16.1 says the period of time is 2 years. 16.2 requires to assist it in saying 2 years from when, and then tells you that, and I say there's no necessary inconsistency if I'm correct about what 16.3 means, because 16.3 then says, but you can break into that period and hold it up, extend it from 2 to 3, if appropriate conditions are met under the local law. Now, I submit that's not an inconsistency. What is an inconsistency is saying that a deferment obtains because a deferment does not accept that the starting date is the date of deemed disembarkation, whereas my variants of interruption or extension if you need the extra day because the court is closed sort of thing do. And I submit that is an indication that the preferable interpretation to place upon this is the one for which I contend over the one which involves the postponement or deferment, or indeed, if the child is young enough, as in here, in this case, time simply wouldn't run at all. And what would simply happen is time not having run, the in no case provision would descend somewhat artificially on the basis that it's cutting down nothing. And essentially what I do in this connection is apply the well-known provision about construction of special and general statutes and say that since this relates to a special statute, the provisions of the domestic law as operated can't be used so as to cut down what is said in the special statute that is directed to this matter. My Lords, having made the basic submission I make about the reason for preferring my construction of suspension and interruption over my learned friends, which is in essence to secure internal consistency in the Athens Convention, I pass over noting the question of the travaux. I don't suggest they are of any assistance to their lordships at all, but it's a matter which we're told we should look at, so we have to look at them. And similarly, the rest of paragraph 10 is largely directed to saying what is the previous authority from the court about this or from the courts of Scotland. And once again, in essence, I regret that the information I'm offering is that it's of no great assistance north or south of the border. One has Higham, and that's really what one has to make do with in this connection. There is something of a dispute between my learned friend and myself about what it is that is of significance in Higham, and put shortly, the dispute is this. My learned friend says that Higham is about extension of the limitation period once it has elapsed, and that, of course, is what was ultimately what was decided. That is correct. But I say that the important point is why that was decided. And I say that was decided because the court said that the thing that had to be met was the establishment of a suspension or interruption which it conceived of as being a break in the tract of time which was already running and which starts this particular argument off in whole. So it is not, as my learned friend would have it, that the passage on which I have placed reliance about the break in the running of the limitation period is obiter. It's, I say, part of the reasoning which is used by the court for saying that section 33 does not attract the benefit of Article 16, sub-article 3 of the Athens Convention, because it's dealing in extension, any more than in the Scottish terms, as it is accepted, 19A would attract the benefit of this. But I say that, as happens with some other countries, the consequence is that there isn't actually anything which amounts to suspension and interruption, certainly not 18.3, which is what is being relied on in this case. So when my learned friend says Higham is nothing to the point because it's about extensions, I say yes it is, because the question is why was it that extensions were said not to be suspensions and interruptions, and the answer was because extensions were not dealing with breaks in the running of the tract of time, which I say is the touchstone here for suspensions and interruptions.
I suppose on your approach, there would be I can think of one example anyway of suspension, which would be if a person were to become insane for a time and then were to recover his reason.
Yes, that is a case that I suggested would be the example in the court below, and we then got involved into all the arguments which are perhaps reflected in my learned friend's case, for his part, about why is it that it happens. If it happens 5 minutes later, it's in, and it happens
Yes,
5 minutes
exactly.
before, it's out, that kind of thing.
Yep.
I accept that. I confess I had a think if I could conceive of other examples beyond that one, and I have to say I have eventually drawn a blank. I did wonder about strange orders under the Companies Act and things, but they don't actually work because they depend on your being able to do it on the underlying legislation anyway. So if I'm right about this construction, one couldn't have a Companies Action restoration order with a limitation direction in it.
Again, you might be pressed on what rationale there might be. I mean, on your approach, the person who is insane on the date of the date specified in 16.2 and remains insane will be time barred in the ordinary period. But if he had a lucid interval
Yes.
on the starting date and then lapsed into insanity a week later, then suspension would apply on your interpretation.
Yes, I would accept that. If it were an unhappy consequence 3 months down the line from the recovery from the injury he unfortunately suffered, that betokens, then time would have run, there would be a suspension, and on it would go. As we've mentioned once before, the contention was made in the court below, well, what is the policy, what is the reason for the differences? And I've already indicated what my reply to that is, which is that it's about certainty on the other side of the coin, and a compromise line has been arrived at, or a line has been arrived at, whether it's a compromise or not. And one simply has to accept that, as in some other areas considered in this court of late years, there may simply be some hard cases, and that's it. But I argue that it is sufficient at that stage to determine the question of what is meant by a suspension and interruption, and in favour of the notion that it is an intermission, a break in the running of the tract of the from the start on the deemed disembarkation date, on the basis of what I might term the absolutely ordinary orthodox approach to these things on international conventions and the appropriate meaning of English language. But I submit that there can be a degree of comfort found, or confidence, or reinforcement, whatever one wishes, on the issue that I canvass in the 11th paragraph of the note of argument at MS 35. And this is when one goes to look to see if this phraseology appears elsewhere. I call attention to the fact that the phrase is not unique to the Athens Convention or anything like it. And the papers contain 3 examples, though one of them is the Rotterdam Rules, is effectively to say that in the Rotterdam Rules, suspensions and interruptions, whatever they are deliberately excluded. But my point is that the phraseology appears, and that what I invite the court to draw from this is that this phrase appears too often for it to be simple coincidence. This means something to someone. It's a shorthand phrase indicating the animal. And indeed, there are more examples than simply the ones that have been produced here. These ones are produced because they're in rather similar sorts of areas of country to the convention with which their lordships are concerned. But it appears in other places. The Rome II rules on choice of law, for example, discuss commencement of limitation periods and their suspensions and interruptions of those periods. The regulations of the European Union on Euratom also refer to things like suspension and interruption of limitation periods in relation to breaches of regulation in respect of nuclear matters. There are no doubt plenty more. But in the 3 that are referred to here, that will be found at MS 307, 309, and 325, what one finds typically is, as in the Athens case, that there is a period of time set down. It is set down from when it is to count, and then usually it is a matter remitted to national law what the suspensions and interruptions are going to be. And I call attention to the fact that originally the Warsaw Convention of 1929 about aerial carriage was also going to feature the phrase, but as is narrated in the La Roche and the Kahn case, Kahn is to be found at MS 355 to 56. There is a narration there about the removal of the phrase from the Warsaw Convention at the international conference stage at the behest of the Italian government. And that was done because of concern about the degrees of uncertainty which would be created and the need to ensure that one simply had a method for calculating the period of 2 years for which Warsaw provides, whilst eliminating from the discussion the issue of suspensions and interruptions, which a number of delegates took exception to, particularly, it seems, the French and the Italians. And that's narrated at some length. Kahn is, I accept, not an Athens case. It's a case about whether or not infancy is a ground for deferring the 2-year period under the Warsaw Convention. The court, unsurprisingly, says no, because suspensions and interruptions had been removed. But for present purposes, its use to the court is perhaps the narration at 355 to 356 of the work that was done at the Paris conference and the removal of suspensions and interruptions, whilst leaving computation of the time period rules in, as now features as Article 29 of the Warsaw Convention. And so I say that this is sufficient to demonstrate that we're not looking at happenstance. This, as I say, is shorthand for something, and that the International Convention interpretation rules allow us to acknowledge that there may be phrases used which are shorthand for things, and I say this is one of them, and that one would therefore look to see what has it been used as shorthand for. And my submissions in that regard are that it derives from a distinction which is recognised in some civilian systems between the situation in which, following the end of a halt in the running of a limitation period caused by the occurrence of some event, the period resumes from the point in its running it had reached immediately before the event occurred, and that in which the end of the halt causes the limitation period to commence afresh from the date on which the halting event itself ceased. In homely Scottish terms, it's the distinction between what we do in a limitation case, suspension, and what we do in a prescription case, interruption. And
Is that quite right? Is it not that, I thought the distinction was that in suspension, if the clock stops running and then it resumes after the cause of the suspension has ceased to apply, it then resumes running from the point at which it was stopped.
Yes.
Whereas in interruption, the clock has to be reset to zero.
Zero, correct. But equally, if we have an interruption of a prescriptive period, the clock resets at zero.
Yes.
And in a suspension,
Yes,
it doesn't. It just picks up from where you got to, which is why I mentioned the sort of the homely example.
Yes, because if you get a relevant acknowledgement, or then you get the extra 5 years on short negative prescription.
Indeed, that's usually the entire value of them, that it gives you a whole new 5 years to play with.
That you say is interruption.
Yes. And I refer in the authorities to a series of materials in support of that contention. And I start with the Berlingeri case, Berlingeri volume, which is at MS 411, I think.
All right, can you give me that page number again?
Sorry, I'm just checking I've got it right, my lord. Yes, it's actually 411 and following.
Tab 26.
It's tab 26. And The general proposition is evinced on 411. Sorry, I apologise, Lord, I've been almost automatically dealing in the MS numbers. I hope that's not, and would His Lordship wish me to do both?
The MS numbers are fine.
At 411, under the heading Interruption, Suspension of the Time Bar, we get told that different rules exist in various systems of law as regards possible suspension, interruption of the time bar, and the effects of such. And then it says the fundamental difference between suspension and interruption seems to be that while suspension causes the clock to stop for a certain period of time, and then the original time bar period commences to run again, in interruption, from the date when the interruption takes place, a fresh time bar commences anew. The same thing is said over the page on at the top of 412, and then there are a number of examples of countries in which there is discussion of what the suspension and interruption arrangements are. In some countries, as will be seen on 413, the Netherlands, there aren't any. My Lords may recall noting that in Higham, when this very book was being discussed by the Court of Appeal, they noted the case of Belgium, in which there were none. Spain has got a reference to both groups of rules of prescription. Civil and commercial code groups contemplate only interruption of time bar. Interruption is distinct from suspension. Former means that a complete period commences to run anew from the date of the interruption. Instead, suspension does not delete the time already elapsed. It only stops the running of time, so time continues to run once the suspension is finished. There may possibly be a speciality about salvage in Spain. May I call attention to Switzerland with something of an apology on my part. Unfortunately, Switzerland has two codes, as my lords may be aware, a code of obligations and a civil code. I'm afraid that the passage which has been produced in the authorities has been accidentally copied from the wrong one and will assist their lordships not a bit. This, however, tells them what was supposed to have been there with the originals. The statute of limitations in Switzerland does not run and is suspended if it has started, section 134, for certain kinds of claim, including ones for claims of children against parents for the duration of the parental power, and then interruption occurs, the statute of limitations under Article 135, in certain circumstances. So there too we're seeing the same types of operation. And similarly, the same kind of material could be seen in authorities which are produced in relation to the Quebec Code, where in particular there is reference to the Baudouin volume, which appears at, I think, MS 407. 407, it's in tab 25, my lady.
Yes, indeed.
And
I noticed that you haven't, you certainly didn't with the Berlingueri, whereas you have with Baudouin, produced a title page.
No, I'm afraid the title page was overlooked with Berlingueri. It's a 1995 second edition, my lady, which is the one that, it's the most recent edition, there are only two, which is the one that the Advocates Library currently possesses. In Berlingueri, the original is here, the supplementary list of authorities, which I think was provided for their lordships, contains, if they find it necessary, the translation. But here there is reference to the definitions of interruption and suspension of prescriptions in Quebec, and once again it says the same sorts of things. At paragraph 1.1326 on 407, or the equivalent page in the translation, there is discussion of the suspension of prescription induced when, during the period of prescription, an event occurs, i.e., simply one may derive from the words during the period concerned, the event occurs, and the event is therefore one which presupposes that time has started to run, and that is an event which stops on a temporary basis, prescription period, and it's different from altering the starting point of the prescription period, and it implies that prescription has begun. Unlike interruption, suspension doesn't deprive the person who is in the process of prescribing the benefit of the period already elapsed. That remains applicable, and as soon as the cause of the suspension disappears, it resumes at exactly the same point it was when it was suspended. Interruption is, by contrast, subject to the definition at paragraph 1-1333.
Yes.
Sorry, I beg my lady's pardon. I'm
That's
tripping
on page
up
1
my
at
own tongue.
409.
That's 409. And there we see that interruption occurs when, again, during the period fixed. For prescription, an event occurs that completely effaces, annihilates, wipes out the period already run, and therefore causes the person who is in the process of prescribing to lose its benefit. Prescription thus interrupted can only recommence if the event itself ceases and disappears, but it then recommences from zero and starts time running again at the same time, and it is no longer possible for the debtor to count on the time elapsed before the interruption. So it's again just the same mechanism operating in the same way. And the authorities produced indicate a number of other countries in which this happens. There are authorities from France, from South Africa, which is perhaps a straightforward one, and Russia in addition. Beg my lady's pardon for a moment. Tab 16 at MS 318 is the South African one, and this is taken from the Prescription Act 1943 in the Union of South Africa, sections 6 and 7. 6 deals in interruption. It's on 319 in the MS pages. Extinctive prescription shall be interrupted by a list of things. And then it says after D, after the indentations, and shall begin to run de novo from the date when the interruption occurred, provided that no period of prescription so beginning to run as a result of admission of liability under an acknowledgement in writing shall exceed 3 years. Then 7 deals in the suspension of the extinctive prescription. It provides that prescription shall be suspended in a number of circumstances. And then subsection 2 says, the period of suspension of prescription shall not be deemed to form part of the period of prescription, but prescription shall resume its running from the date on which the suspension ceases, and shall be completed at the expiration of a period which, at the date of commencement of suspension, is equal to the unexpired portion of the full period required by this Act.
But 71A suspends extinctive prescription so long as the performance of an obligation is delayed by vis major, or the debtor is lawfully entitled to delay performance on any other ground. Yep. Is there any suggestion there that the suspension can only occur if those events occur once it's started to run?
Yes, my lord, because I say that follows from 7.2. Prescription shall resume its running from the point at which the suspension ceases and shall be completed at the expiration of the period that's left. That presupposes that time has run before we start.
If
you say resume,
yes,
presupposes.
Yes.
It's the word resume.
That might be so if one just looks at that. But if you look at example E in subsection 1, the actions founded on fraud, there is still suspension until the date when the creditor might reasonably be expected to discover the fraud. Now, it's impossible to think of a period starting to run and then stopping in that context. And if you include among disability one caused by minority, the same would be true in B. And on the face of it, in D, all in subsection, all of which are treated as examples of suspension.
Right. If I
take them in turn, I'm sorry, it was a bit of a blockbuster.
Okay, you're right. The point that my lord makes about fraud, I would answer in this wise in saying that it is presumed that the period of suspension arises as a suspension because presumably there is a period where time is running because there's no reason to believe that he understands anything of the fraud. In the case of the disability, one is looking to the disability which, as I would say, is one which strikes during the period concerned, so that we can have this resumption, because the notion in 2 appears to be applying across the board, and if this is to be internally consistent with itself, presumably the others have to operate in order to make that make sense. And as far as the matter of minors are concerned, I understand that as at common law in South Africa, at least, prescription simply didn't run against minors, so you didn't need to worry about them. They're not part of the disability. It simply didn't run in their case, so there was no call to deal with a suspension or interruption in relation to minors because it's not something that's going to affect them. They're not persons against whom time runs in the first instance. It is fair to say, my lords, that the provisions of this legislation were subsequently altered in 1969, and what took place will be found in the case of APB 4x4 motor dealers in tab 21 MS 332 and following. What happened in relation to section 6 and 7 was that they were replaced by section 13, which will be found at the foot of MS 336, where it's provided that if A, the creditor is a minor or insane or a person under curatorship, etc., and turning over the page to 337 and letter I, and the relevant period prescription would, but for the provisions of this subsection, be completed before or on or within 1 year after the day on which the impediment referred to in, amongst others, A, ceased to exist. The period of prescription shall not be completed before a year has elapsed after the day referred to in paragraph I. On paragraph 8 across the page at MS 338, the judge says that before considering the contentions made in that case, we as well to understand the fundamental import of section 13 of the Act. It's a provision which provides for neither the interruption nor the suspension of the running of prescription in the normally understood sense, but traces of it remain. And then he goes on to point out 9 and following that the way it works is that you get a bit of extra time if you finished in the last little bit that would have elapsed. So how much additional time you get depends on when the curatorship, as it was in that case, or impediment disappeared. At paragraph 13 at 339, he says, further light is thrown upon the question when the Act is compared with its predecessor, the Prescription Act of 1943. In the 1943 Act, distinction was drawn between the delaying of the commencement of a running of prescription and the suspension of the running of prescription after it had commenced running. I note, after it had commenced running, my lords. Thus, Section 7 provided for the suspension of the running of prescription in prescribed circumstances, one of which was the disability of the creditor, and its resumption on the date when the suspension ceased. And he says, in the case of a disability, that would obviously be the date on which it ceased to exist. And then it provided for the completion of prescription by adding on the period which had already run when suspension occurred. Whatever period of time would be required to make up the prescription prescribed by the Act for prescription of the particular debt. And he then proceeds to go in for, to give an example. And if I pick up H, he says, in other words, the 1943 Act provided only for the suspension of the running of prescription and did not provide for extra time over and above the originally applicable period. They then look at sections 9 and 10 of the 1943 Act, 9 having said, where there was creditor was under disability, extinctive prescription shall not begin to run until the date of disability ceases. And then at 15, over the page, what is striking in the present Act is that circumstances which would have delayed the commencement of the running of prescription in terms of 9 and 10 no longer have that effect, nor where such circumstances arise after prescription has commenced running, do they necessarily result in suspension of the running of prescription or a delay in the completion of the original applicable period. And that what happens, as he says, 3 or 4 lines from the end of that paragraph, is that the period is extended so as to make a full year available. If more than a year remains available, the existence of the circumstance postulated will have no effect on the running of prescription at its completion. So what we see from that is that, as it were, in answer to the point made by my Lord Hodge, we find that the court saying that what is intended is indeed a resumption of the kind I was talking about, when the date for the suspension ceases and you add on the requisite time. I think that lastly in this connection, there is produced a translation of sections from the Russian Civil Code, which, just put shortly, show the same sort of thing happening. There is a suspension and interruption time either starting anew.
Which tab is that?
That, my lord, is at tab number 20 over the page. It is MS 329 following the passages. They're all actually on 330. They're articles 202 and 203.
I'm so sorry, which...
Give the page numbers
Certainly.
again. You're talking into
Sorry,
your boots.
I beg my lady's pardon. She's quite right to correct me. I shall put it up so that I don't do that anymore.
Well, you're already speaking very softly. I imagine those at the back of the room are having trouble hearing.
I apologise both to my lady and to those at the back of the room. I acknowledge that it is a bad habit of mine. I'm repeatedly pulled up for it elsewhere.
Oh, I'm glad I'm not alone.
No, my lady is sadly in all too much company.
So the page number?
The page number is MS 330, 330. And the articles are 202 on suspension and 203 on interruption. And they say the same sorts of things as one has seen already by now several times about when time recommences in each case.
An interesting example here is under Article 202, paragraph 2. There's suspension if one of the parties is in the armed forces.
Yeah.
I wonder, can one say, putting it in a sentence, that looking at the civilian systems, again, one sees that there are some where suspension is used in the sense that the period has to have started running, for example, Switzerland, and there are others where it's used in a wider sense that doesn't carry that implication.
Well, my lord, I imagine depends on how my lord reads them. I submit that these don't appear to carry out. The general proposition that one sees time and time again is about resumption in suspension cases and running anew in interruption cases, and that both of those postulate that time must have been running in the first place.
Well, that's the second part of your submission, yes. And that's what we have to think about.
Correct. That's the crucial... If my lady said this is a short point, that was probably the one she had in mind.
Yeah. So do you submit? I mean, what the Russian law actually is neither here nor there. But do you read the one I just drew to your attention as meaning that a party being in the armed forces is of no significance if he's in the armed forces on the date when time would begin to run? It's only significant if he joins the armed forces on some subsequent date.
Yes, my lord, and the reason I would do that is because of paragraph 3, which tells me that the running of the period shall continue from the date of the termination of the circumstance.
And how do you deal with French law?
Right.
The causes that suspend the running of prescription, and one of the first examples given is minority.
Right. How I deal with French law is there are a supplementary list of authorities because a question was asked about French law. So the view was taken on both sides of the bar, and I acknowledge the assistance of my own friends in this, that we should provide the court with all versions from 1804 onwards. And what I derive from these is that from 1804 onwards, we see references to interruption and suspension of periods, but that what happens is that there are persons against whom prescription just doesn't run at all, and minors seem to be numbered amongst them for most of this period. The 1804, for example, the article number is 2252, and that remains the article number for some period. It provides prescription does not run against minors and those who under interdiction save in case set out in 2278 and others determined by law. So the basic
this is under the heading causes which suspend the running of prescription.
Yes, indeed it is. And then it turns out, and my Lord will see it's not the only one that turns out where it just doesn't run at all. The next one, 2253, it does not run between spouses. So the headings may be a trifle idiosyncratic.
So what happens when the minor achieves majority?
When a minor achieves majority, then presumably in France, he then becomes subject to whatever are the limitations that run if they continue to have any relevance to whatever was the issue however many years ago it was. This remains basically the position down to the 2005 version, which is in the supplementary bundles, which is the Bruchette version, and by then it is still saying at 2252, prescription does not run against non-emancipated minors and adults in guardianship except in 2278 and other cases determined by law. But when their lordships come to look to the next one, which is a translation as at September 2014, there has been a change, at least in the text, because at no stage in the text hitherto has the French Civil Code told one what the suspension or interruption is, and indeed, as my Lord Reid points out, a number of the examples actually are about it doesn't run at all. And because it was found that this was causing confusion between the situation where there were deferments on the one hand and suspension and interruption on the other, in 2008, the legislation made the point clear, and the article, the Civil Code comes to include new articles, and in particular, they are articles 2230 and 2231.
Where do we find this in the supplementary bundle, please?
I think it's page 45 of the supplementary bundle, tab 7.
My Lord is correct. 45 is the answer.
Thank you.
2230 provides suspension of prescription temporarily stops its course without erasing the delay that has already run. So it is postulating suspension is an animal which exists where time has already been running and then gets stopped. Article 2231, interruption erases the delay that has elapsed. Again, it's an animal that exists only where there's been prior running of time. It causes a new period of time of the same duration as the former period to run. 2232 says, the deferral of the starting point, the suspension, or the interruption of prescription cannot have certain effects. It doesn't matter for present purposes as I submit what they are. What matters is that we are distinguishing between deferrals of start point and suspensions and interruptions.
Well, it does matter, doesn't it? Because 2232 is basically treating deferral as an illustration of suspension, but putting a long stop date on it.
No, my lord, I would submit that what it appears to be doing is saying that whether one operates in the case of a deferral, a suspension, or an interruption, the long stop cannot be exceeded.
But you only need a
Elsewise-
long stop if the deferral is being is extending. I mean, unless it's something that interrupts the running of time, 2232 makes no sense.
Of course, the following articles define what is meant by causes of deferral,
Yes, it goes on to deal
which includes minority.
yes.
In
Minority
2235.
is,
Yeah.
yes, minority appears to,
It does not
Yeah,
run
form
or
of-
is suspended.
Yeah.
that's what I was going to say.
Yes.
It
Yes.
appears to be
Yeah.
an example of suspension, which it makes me ask whether the essential difference between interruption and suspension is nothing to do with whether time has already run, but with whether, if it has, it is included when the clock starts running again or not. Interruption not included, suspension is included, but that begs the question whether any time started to run in the first place. So difficult to see how, otherwise, how minority could be described as an example of suspension.
Well, that's the point I put earlier.
Yes.
It's one thing to have different consequences, and it's another thing to have the different assumption as to whether it must already have started.
Well, the answer which I offer to this, because I see entirely why these questions are asked about this particular article, it seems an obvious point to be taken to challenge me with, is that what one is looking at here is that it does not run against minors, and the suspension is distributively dealing with adults in tutelage, because otherwise it is difficult to understand how that would be internally consistent with saying suspension of prescription temporarily stops its course, i.e. prescription stops its course. It's already happening, and therefore suspension is an animal which can only exist in an atmosphere in which time has begun to run earlier. And therefore, as everyone agrees, it's impossible that minority should meet that requirement, and therefore the way that one makes 2235 makes sense, that I suggest at least, is that or is distributive.
We have to remember that we're trying to decide what, insofar as the French text is concerned, what a reader would have understood it to mean in 1974, which is, nearly 40 years before this version.
Correct. I entirely concede that point. It's one of the points made by Lord Hophouse when he says, and in a way, holding this discussion about the law of France, it's a terrible warning to us, because he says one of the things one must not do is concentrate on the specific rules of any given legal system.
No, quite. I mean, the point is that the French text is authentic, and therefore the meaning of the French word is relevant. And the only reason for looking at any of this is really to try to help us understand what people would have meant by the French word when they used it in the treaty in 1974.
Well, when they used the words in French or in English, for they are the same in the treaty, there is, I haven't taken his lordship to it because it's not contested that they're other than the same, was being meant as for this purpose, the shorthand. And the reason I'm putting the court to this is another way of looking at what I say is consistent with what I say follows the ordinary English. And I say it makes one comfortable about saying, well, yes, that is the answer. But the danger that one has to guard against is looking at it and trying to work it out by reference to results in specific legal systems, because that's an error which I say is going to be committed again by the respondent when they look at Scots law and say, well, why would it be that if 18.3 has the difficulties that I say it does, doesn't that mean that all sorts of hard cases result? To which I say, and why are we saying that an international agreement about what this is to be is a dog to be wagged by a Scottish tail, because of an unhappy effect that it might have in relation to Scotland or an unhappy effect it might have in relation to any other country. Which is why one has to be a little careful of arguing backwards from things like 2235. I apologise, my lord, I talked
You
across.
can't surely interpret the word suspension or interruption in Article 16.3 by reference to any national system, because it's deliberately, as you pointed out earlier, it's got to have an autonomous meaning, but it then has to be applied to a very large number of different legal systems. And all of this interesting excursus through the French, Russian, Belgian law, etc., illustrates is the variety of ways in which 16.3 can apply in different legal systems. I mean, it doesn't actually tell us any more than that, does it?
Well, what I put it before the court, I say it tells, I agree, it tells the court that, and I say further, I say look at this common, the common features about resumption and anew, the critical factor that Milady and the chair identified. And I say that is what the beast is, because that's the common thing we're seeing turning up across Russia, all these other countries. I'm quite deliberately trying to avoid any suggestion of a concentration on any given legal system, and therefore using what it is that the shorthand is being used for the animal and saying it's about this. And they all postulate that time has run in advance. And if there are special odd examples like the armed forces in Russia or whatever else, that's all very well and interesting. But that's what Lord Hobhouse has told us is working backwards and in the wrong direction. And that's why I argue for the two-stage test. And as my Lord says, the reason I put this material is to try to show here is a common feature operating in broadly the same way, triggered no doubt by different things, but they're what one doesn't concentrate on. And that one doesn't interpret the autonomous meaning by reference to what might be, let us suppose, whether this is or is not, an example of a drafting difficulty in the legislation of one particular country. And it has to be remembered, too, that when my Lord Reid puts to me, well, the French text is equally authentic, that's true. But, of course, there are many more Francophone languages than just French, and many more legal systems that use it, which may have other and different things. After all, this is a Scotch appeal. We've had an English case on this in Higham, and there are no doubt others in Anglophone. Well, we know there are. We've seen the Canadian ones, which say different things. And equally, come the 2002 protocol, the United Nations now has a whole series of more authentic languages. They add Chinese, Arabic, Spanish, Russian. One can't argue from specialties of whatever language, legal systems there may be, which use Arabic or Chinese or whatever else. The attempt is to find what is the common feature, and that's why I have indulged in perhaps this level of overkill about differing legislative provisions to try to identify a common denominator which would be the features of this animal and what kind of landscape is it this animal can exist in. And I say the common thing is that it has to be a suspension time has already to have run or begun running in order to allow us to deal in suspension and interruption. And I say, therefore, that this appears to support what I have been contending for in relation to the ordinary English meaning and usage. We see it also for, I will just mention this because it's simply adding another one, MS 425 for the law of Spain, in which we see it explained by a Spanish academic, or rather, we don't, the title is missing again. But 425 is taken from a volume called Talk on Spain by a Spanish professor. And paragraph 272 and 425 tells us about Spain featuring the same sort of thing. And therefore, unsurprisingly, one could have gone on to produce a whole series of South American arrangements which have got a Spanish ancestry. there may be a little merit at this point in calling attention to one of the Canadian cases again, Russell, tab 24, in particular MS pages 395 to 396. In particular, paragraph 48, to which I call attention, where here the judge, this is the New Brunswick Court of Appeal, is discussing the Athens Convention in Article 16. And one may note that not only at paragraph 46 does it agree with Hyam that in the last line, Article 16 does not provide for any judicial discretion to extend the limitation period, but in 48 it says, in the law of a limitation, postponement, extension, suspension and interruption are distinct devices.
So where are you reading from?
Sorry, I beg your pardon. MS 396, paragraph 48, the last 3 lines on the page.
Right, thank you very much.
In the law of limitations, postponement, extension, suspension and interruption are distinct devices that may relieve against legislated time bars for the bringing of actions. The extension of a limitation period typically involves judicial extension, where the other discretion, whilst the other 3 arise by virtue of circumstances prescribed by law. In that regard, it's noteworthy that Article 16 refers to the law of the court seized of the case as a source for any grounds of suspension and interruption, and that it adverts to neither extension nor postponement. It appears, therefore, that at least in New Brunswick, the Court of Appeal holds to the view that suspension and interruption are animals which have the features which I contend for, because they say Athens does not allow for postponements, which would be deferrals such as would be necessary in a case of minority. With my apologies for detaining their lordships, I should perhaps note also one of the points that's taken against me in this connection, which derives from the textbook on prescription and limitation written by Mr. Johnson, QC. It's at tab 7. The MS page numbers are 293 and 294. And, my lords, I submit that these shortly don't afford any support for the view that a deferment is possible as a suspension or interruption. What I understand to be taken against me in this connection is at paragraph 10.94, where there is in bold a subheading called suspension of the limitation period. Whether that's the author's words or those of his sub-editor, I don't know, but I submit it's in either event unlikely to be of great assistance in construing this legislation. But in respect of section 18.3, which we're to come on to, at 1094, it's observed that non-age ends at the age of 16. The effect of 18.3 is that a limitation period which has already started to run, he says, is suspended for the period of legal disability. And he then draws a contrast in 1095 between section 17 position, where the disability is, of course, of the injured party, and 18, where it's not the pursuer's disability which is involved. Halfway through the paragraph it says, here the limitation period for each child's claim will not commence until he or she reaches 16, and the period for any individual pursuer affected by unsoundness of mind will be subject to further adjustment. That, my lord, insofar as it's of any assistance at all, because, of course, in fairness, the learned author is talking about the domestic situation in Scotland, let's say in a road traffic accident, where I wouldn't quarrel any of it for a minute, is indicating that what happens with the operation of 18.3 is that periods of time, it's about start date, it's about when the limitation period commences. It is not about suspension, which is what your lordships are concerned with in the instant case. 11.6 is cited against me, but I suspect in error because it's about defamations. What I think was intended to be cited against me was that the provisions about 19CA apply in personal injuries cases as they would for a defamation. 19CA is quoted in the authorities. It's the section which of the 1973 Act which deals with arbitrations. And it provides, it's at MS 151.
MS?
151.
151, thank you so much.
That any period during which an arbitration is ongoing in relation to a matter is to be disregarded in the computation of a period under, and I'll just read short, 18.2. Interestingly, of course, in the application of the Athens Convention to the United Kingdom, arbitrations are to be dealt with in the same way as actions. So in fact, as it happens under the Athens Convention, if one were to postulate an arbitration about the personal injuries, then it would have to be raised within the 2 years, just like any action would. And that's paragraph 7 of the application to the UK, which is MS page 140. Again, I think the significance that sought to be taken from 19CA by my learned friend is the side note which calls it interruption of limitation period arbitration. But the text is actually about the computation of the period, and I say that's not, so far as we're concerned, anything that would count as an interruption. That's called an interruption of the loosest of orders because it doesn't appear to interrupt anything even as a matter of ordinary English. It's perhaps, if I may say so with respect, an example of why side notes are often regarded as rather poor guides to the significance of the text that is to appear in the actual operative drafting. So those, my lords, are my submissions indicating what it is intended to be meant by the autonomous meaning, if I may borrow my Lord Sumption's phrase for it. And I then have to ask, does section 18.3 meet this requirement? And I say no, and the reasons for which I say no have been set out at some length in the statement of case. And I say, first of all, that one has to look at section 18.3 and ask what kind of section is it? 18.3 will be found, my lords, on page MS 148. Section 18 says this section applies to an action which, following personal injuries, damages are claimed in respect of injuries of the death. Subsection 2 says, subject to subsections 3 and 4 below and section 19A of this Act, no action to which this action applies shall be brought unless it is commenced within a period of 3 years after, and there are a series of possible alternatives, and of course one goes for the later of the alternatives. So that 18.2 is about working out what the starting date for limitation in personal injuries and death claims are. And then it says, in 3, where the pursuer is a relative of the deceased, there shall be disregarded in the computation of the period specified in subsection 2 above, any time during which the relative was under legal disability by reason of non-age or unsoundness of mind. And
so the mechanism is that it doesn't alter the start date, but disregards the running within a period.
It's, on the face of it, its form is that it's about how to count to 3, as it were.
Yes.
And what it is doing, I say, is that it is part of the mechanism for dealing in the start date. It works out what the start date is for a given accident or death, different set of injuries, where they happened on a given date, and you don't just count from, let's say, date of death plus 3. You count to get to 3. You count, it may be 5 times.
That is the result, but the mechanism is that the start date remains 3 years, let us say, from the date of death of the deceased. And then in 3 it says, with that start date, we have a period to compute. And the first and the first period, let us say, if someone is under legal disability by reason of non-age, is disregarded. That is the mechanism that the statute has adopted.
Yes. And
so the consequence may be that there is the full period to run thereafter, but it is a statutory mechanism which maintains as its commencement point the date of death.
I am tempted to introduce the words scintilla temporis.
Yes, exactly.
it's a Scots repeal. My lady may do so if she wishes.
It's all right. We're happy with Latin in this court.
It's a UK court.
Yes, in whatever of the two languages my lady wishes, I quite accept that what we have in form here is a computation arrangement. But a computation arrangement, I say, firstly, that is not an arrangement that is not a method of suspending or interrupting any running of time. That's about, as I say, getting to a start date in effect, and what calendar period elapses between the date of death and the legal start date. It is, in either event, about determining when it is the 3 years will count from. And
that's
it's
the consequence.
Part of the exequence. Yes,
that's the consequence, not the mechanism.
I'm not suggesting it's the mechanism, my lord. The mechanism is that you, as I put it, how to count to 3. But that how to count to 3 is not a method of suspending or interrupting any period of limitation. The period of limitation on that view remains exactly the same. It starts at a different time because the mechanism has said that the time, the number 3 will not elapse until more than 3 calendar years have elapsed. And therefore I say, if we're going to look at the mechanism that's being used and the form of the drafting, that is not a suspension or interruption on either ordinary English meaning or by reference to the foreign material at which we have been looking. So I say that that is a different type of animal, and it doesn't qualify for the kind of animal that we now know we're looking for in seeing the suspension and interruption. If one looks more generally and says, well, what is the effect? Then I say the effect is that it may cause indeed, in essence, limitation not to run at all if the child is young enough, because if he has got more than 3 years or more than 5 years now to go until he will achieve majority, time will not on this theory run at all. And that, I say, is, again, inconsistent with the idea of suspension or interruption, or from time running from the date on which the child's father, in this case, would have been deemed to disembark. And I say, as I have said before, one can't have a suspension or interruption which has an effect contradictory of what we're told in Article 16.2. And what 18.3 is doing is dealing in an arrangement which is tied into the mechanism of 18.2, which is said to be subject to subsection 3, i.e. subsection 3 is part of what one has to do to arrive at the start date mechanism for which section 18 as a whole provides. this is not, 18.3 is not self-standing. And if, as has been held in the court below, and I submit quite rightly, 18.2 is disqualified as a candidate for suspensions and interruptions, 18.3 goes with it. I was attacked for that submission, which did not find favour in the court below, because it was said to be too narrow an approach. Because I said, look, Article 3, subsection 2, is specifically talking about the subsection 2 period. And if subsection 2 is contradictory because it's a different start date, then 18.3 can't be saved independently of 18.2. And I submit that that follows from the drafting, not only from the cross-reference to 18.2 in 18.3, but from the fact that 18.2 describes itself at the outset as being subject to subsection 3, and that therefore we're looking at composite drafting, which would be doing exactly what we can't do, which is having a domestic provision inconsistent with the express terms of 16.1 and 16.2 if we imagine that they operated in an Athens context.
Of course, 18.2 is doing two things, isn't it? It's prescribing the period of time, the 3 years, and defining the start date.
Yes, it does do that. That is
It
correct.
does both things. It's not simply a start date provision.
But the only reason one's interested in the 3 years is floating in the air meaninglessly without the start date. You've got to anchor the one into the other, or the whole
True,
system
but you
doesn't
need
work.
the 3 years thing.
Yes, it's got those.
That's the guts of the matter. You've got 3 years.
You've got 3 years, but the start date isn't altered by subsection 3. The computation of the period is.
But if one allows for a start date, which is a deferral, that in my submission is in essence altering the start date because a deferment is counted from date 2, not date 1.
But if you look at the statutory words used, you're disregarding in the computation of the period specified in subsection 2. That period is 3 years from the date of death of the deceased. So it is a computational disregard, not a deferral of start date.
Mm-hmm. But the effect that that has is that it does exactly the same thing. And in my submission, the effect is what will matter here, because what we are interested in is saying that the Athens Convention effectively puts out, if I've been correct about, for example, what one is intended to do in securing that one is looking to ensure that one knows where one stands and when one concludes one's book, for example, one is interested in knowing what that is, as opposed to a situation in which one has got no safety beyond the in no case clause, because this would mean, on the face of it, that if the child is young enough, then time could be deferred in the way that we're used to it being deferred in ordinary domestic cases in Scotland, but which is clearly not the intention of the Athens arrangements. Now, my lord, the last point that was taken against me in the court below was the effort to read the Athens Convention and 18.3 as though it featured in the Athens Convention. Again, this is a point which I suspect I can't elaborate very much beyond what I've said in paragraph 19. I regret to have to submit I cannot see a warrant for doing that in either direction. There is no cross-reference, as my lords have seen from the Canadian cases. As it points out, there just isn't a basis for moving from, in that case it was Canadian provincial law, into the Athens Convention or vice versa. The mechanisms that's used is one applies the Athens Convention alone, and the Athens Convention says for the animals that qualify as suspensions and interruptions, and to see what they are in a given country, you may look at the law of the forum. But that's all. And one doesn't read 18.3 as an interpolation into the International Convention or even the Merchant Shipping Act simply because it exists for Scottish purposes and Scottish purposes alone. And one doesn't work the other way around either. There is no connection between the two. What we have here is an arrangement which has purely domestic effect and importance, and that does not reflect itself in the Athens Convention. All that the Athens Convention does is says the lex fori can deal in things which are properly suspensions and interruptions of the time. And since, as I say, that presupposes that time has to be running in the first place, it is impossible that nonage should qualify as that. I should perhaps lastly say a little word about the issue which was canvassed about unsoundness of mind. Again, I've set my case out in the statement of case about this, that unsoundness of mind is not a matter which has any connection to what the right answer is in connection with nonage, but is one which one could see could allow one to have forms of suspension in the event that, for example, as my Lord Reid canvassed with me earlier, the thing struck as a consequence of the accident or within the period of the time of the accident. But again, it has the danger of looking at a given special legal system which happens to have evoked unsoundness of mind in with nonage. That doesn't necessarily follow for all legal systems, and it may simply be that, again, this is a consequence of the decision that has been reached as to what the legal structure is to be, and that the legal structure of the Athens Convention and the international arrangements does not depend on any particular legal system or how it deals with or may deal with temporary unsoundness of mind, permanent unsoundness of mind, or whatever. And if there are cases which fall 5 minutes on one side of the line and 5 minutes on the other side of the line, as I'm taxed with in the respondent's case, I say that may simply be a circumstance that follows necessarily from having divisions and a decision that this is how we're going to do it. We draw a line here, we draw a line there. People will therefore necessarily fall on one side of the other of that line, perhaps very close to it. That may be unfortunate, but axiomatically it's not a basis on which one forms views about what the correct construction of the law is. So, my lords, my overall submission is that the requirement for being a suspension or interruption is one which minority cannot and does not qualify. It follows that section 18.3 cannot, in the context of nonage at least, afford a pursuer, and in particular this pursuer, a ground for saying that that is a suspension interruption which enables them to escape the toils of Article 16.2 and the failure to sue in due time under the 2 years. And if that means that there are cases where, as we are told in some of the textbooks, not infrequently happens, the cases are missed and that people lose their claims, then no doubt there are parallel claims on against others, but that is just a consequence of what happens in lots of places in the law. And it may be, therefore, that one ends up with one set of insurers paying on another set of insurers, but that's simply a consequence of the law that has been provided for. What one has here is, I submit, a coherent international arrangement in which suspensions and interruptions, whether we look at it through the ordinary meaning, internal consistency of the Athens Convention, or by reference to the foreign material, postulates that time has run already. In the case of minority, that has not and cannot have happened. The conclusion is that minority does not afford a suspension and interruption of the limitation period, and no doubt the intention of the Athens Convention is that the legal representative of the minor will sue in time, and if they don't, that's a private matter between them and the guardian. My Lords, I submit therefore under the reasons that the action is out of time, and accordingly the motion which I make to their Lordships is that they should allow this reclaiming motion, and in consequence, because it will have been raised out of time, as has the claim in her own individual right by the widow, which has already been dismissed by the Inner House, the action as at the instance of the guardian should likewise be dismissed. However, because there are matters of expenses in relation to the procedure which has taken place in this case in Edinburgh, it would be appropriate, even if my reclaiming motion be successful, that my Lords remit the matter back to Edinburgh in order that the appropriate steps may be taken to put your Lordship's interlocutor into operation and to allow the matters of expenses before the Court of Session to be canvassed in that court. Unless there is any other matter which my Lords consider that I should have canvassed or that they wish to canvass with me, those would be the submissions in support of that motion which I should address to them.
Thank you very much indeed, Mr. Howie. Ms. Chatteris, do you wish to follow?
My Lords, I have nothing further to add.
Thank you. Well, we'll adjourn just for a little while to see where we are. Now, Mr. Milligan, we have decided that, much though we would like to do so, we have no need of your submissions in order to resolve this case.
At least I'll be able to say, if anyone asks me how my appearance went, that I was flawless.
Yes, indeed. Thank you. We will, of course, prepare a judgment in writing and let you know our reasons in due course, as soon as we possibly can do that. So the court will now adjourn.